SMU constitutional law professor Dale Carpenter, thank you so much. We appreciate it as always. So as you know, there are these conflicting opinions by two separate federal judges when it comes to the FDA and medication abortion. What do you make of this?
Well, it's highly unusual that you'd have two conflicting opinions on an issue like this in such short order. I think one of them came down just literally half an hour or less after the other one. And we don't see things like this happening very often.
What's going on here, do you think? I mean, because you said this is so unusual.
Well, I think there's a lot of uncertainty and instability in the law now that Roe versus Wade has been overruled. And so I think various parties, especially opponents of abortion, are trying to test the limits of their ability to place restrictions on the practice all around the country.
And so here you have the federal judge in Texas basically taking issue with the FDA's review process, not only back in 2000, but also in 2021 when the agency allowed mifepristone to be distributed through the mail. And then you've got the federal judge in Washington state saying that the FDA's restrictions are too tough. So how does this all get sorted out in the end?
Well, I mean, obviously, these are judges with somewhat different judicial philosophies. On the one hand, in the Texas Judge Kaczmarek, is appointed by President Trump, and I think is a much more conservative judge. And he's less willing to accept the word of the FDA and its review process that these drugs are safe and effective. And then you've got a judge in Washington who was appointed by President Obama, who's much more likely to err on the side of giving doctors and patients the ability to make decisions for themselves without too much interference from the federal government. So you've got different judicial philosophies at stake. And I think we have this all around the country now, where judges just come to different conclusions based on those predilections.
And so we know that the Biden administration has filed an appeal to the Texas judge's ruling to the Fifth Circuit, where you once served as a clerk. Do you think this is headed right to the Supreme Court?
Well, I think it can be headed to the Supreme Court in the sense that whichever side does not get its win, at least temporarily, in the Fifth Circuit will probably try to go to the Supreme Court. It's very telling to me that the judge in Texas stayed the effects of his decision until this coming Friday. Well, the Justice Department asked the Fifth Circuit to rule by noon on Thursday. And if they don't get a ruling by noon on Thursday from the Fifth Circuit, that signals to me that they are going to go straight to the U.S. Supreme Court and attempt to get the judge's order stayed in that forum.
My question really is, what are the constitutional questions here? Because after, last year the Supreme Court overturned Roe v. Wade, they sent it back to the states. So do the federal courts even have any jurisdiction over this?
Well, that's a very complicated question. There aren't actually really many outstanding constitutional questions involved in this litigation. Really, the issue here is that you have a federal agency regulating, and courts usually defer to the judgment and the expertise of those agencies. When they say that a drug is safe and effective, especially when it's now been on the market for more than 2 decades, that usually stands, and it's highly unusual for a court to take the position that now that decision was erroneous and has to be halted. So I think you've got an issue of federal law, but not necessarily of constitutional law. I think the constitutional law issue about Roe versus Wade is not directly involved in this litigation.
It's
a question of deference to federal agencies that federal judges usually invoke.
Are there separation of power issues here?
There could very well be separation of powers issues if the federal judiciary is now going to second guess and superintend those agency decision-making processes and again, cite their own judgment about medical efficacy and safety. That could raise a question of whether the judges are now intruding themselves into policymaking and the role of the executive branch.
And that would be inappropriate?
That would be a violation of the separation of powers. We have these doctrines so that the executive branch basically executes policy that's formulated by Congress, and the judiciary's role is a very limited role, trying to make sure that the executive branch, the FDA in this case, hasn't acted in an arbitrary and capricious fashion. And it's very hard to say that the decision was arbitrary and capricious because there's really quite a bit of support for the decision that was made by the FDA after more than 20 years ago.
What do you make of some Democratic lawmakers who are calling on the Biden administration to defy the court's ruling if it ends up, where the judge's ruling would stand?
Well, I think those kinds of pronouncements are more political than they are legal. I think they're more a statement of advocacy of women's reproductive freedom than they are legal statements. I expect that the Biden administration will abide by any valid holding that the courts issue. Of course, the Biden administration can take this issue as far as it can, but at the end of the day, I think they'll abide by the law as declared by the federal courts.
And at the end of the day, even if the FDA is ordered to go back and review and all that, I was reading that it could take years, if it ever came to this, for the FDA to pull the drug off the market. I mean, we're not talking about something that could happen anytime soon.
That's right. I think we're in such uncharted territory now. It's hard to even talk about timelines, given that how much the drug is out there. I think there have now been more than 5 million women who have taken these drugs in the past quarter century or so. And I think there are huge questions about whether the plaintiffs who tried to overturn the FDA's decision even have standing in federal court to do so. And I think there are large questions about why it is that they waited so long to bring this litigation.
And would there be statute of limitation issues here?
Yes, very much so. I think that's going to be a big issue going on up and going forward.
And I have two other quick questions for you. Maybe they're quick, I don't know, but it's quick certainly to ask. And that is legal issues here. Here you have a judge in conservative Texas, a judge in liberal Washington state, and this brings up the question of forum shopping. One side goes to one place where they can get a favorable ruling, another side picks another court where they can get a favorable ruling. Isn't this a problem?
Yes, I think it is a problem. It's increasingly a problem all around the country, and it's a problem that is magnified by the fact that these judges, like the one in Texas, are issuing orders that have nationwide effect, so that this judge in Texas can purport to bind people in New York and California and other places to his ruling. And of course, what's sauce for the goose is sauce for the gander. So a judge in another place could bind agency officials in Texas as well. I think these nationwide injunctions are becoming more common and probably more problematic as we go forward, because we have so much disagreement in the courts about what the right way forward is in terms of judicial interpretation.
Yeah, I was going to ask you about these national injunctions, because here basically you're having a single judge casting casting established law aside based on his or her ruling.
That's right. And I think that's something that the Supreme Court and maybe Congress are going to need to try to start reining in some of these nationwide injunctions.
All right, SMU constitutional law professor Dale Carpenter, thank you so much. We appreciate your insight as always.
My pleasure.